the power under Article 371D is the same as issuing a notification under Article 370, Clause 3, which the President has the power to unilaterally issue. The principle of consultation and collaboration are not required to be followed. Fourth, the exercise of power is mala fide only if power was exercised with an intent to deceive. Deception can only be proved if the power which is otherwise unavailable to the authority or body is exercised, or if the power that is available is improperly exercised. Since the concurrence of the state government was not required for the exercise of power under Article 370(1)(d) to apply all provisions of the Constitution to the state, the President securing the concurrence of the Union of India on behalf of the state government is not mala fide. The next issue is the challenge to CO 272 on the ground that it is ultra vires Article 370(1)(d) because it modifies Article 370. We have held that the modification by CO 272 to Article 367 as it applies to Jammu and Kashmir had the effect of amending Article 370 and is thus ultra vires Article 370(1)(d). We have reached this conclusion for the following reasons. First, recourse must be had to the procedure contemplated by Article 370, Clause 3, if Article 370 is to cease to operate or is to be amended or modified in its application to the state of Jammu and Kashmir. No other procedure may be utilized to amend Article 370. Second, the rule of interpretation that a power under a statute must be exercised in accordance with the provisions of that statute and in no other manner is undoubtedly applicable to the Constitution. Third, from precedent, including Shankari Prasad Singh, Sajjan Singh, Quixote Holohan, and Rajendra Shah, it emerges that the following aspects are of significance when assessing whether a change has been made to a provision of the Constitution. One, a change may be either in terms of or in its effect. Two, a change can be said to have been made even if the language of the concerned provision is not directly amended by adding, subtracting, or modifying the language. This is a change in effect. And three, if the effect of an amendment is to change a provision, such effect must be significant or appreciable. And four, the substance of a change is more important than its form. Second, an assessment of whether a constitutional order amounts to a modification and consequently whether the procedure under Article 370, Clause 1 or under Article 370, Clause 3 ought to have been followed depends on this standard. Third, the effect of a provision of law is as important as its form. While the change sought to be made by paragraph 2 of CO 272 may appear to be a modification or amendment of Article 367 at first blush, its effect is to amend Article 370 itself. CO 272 changes the language to the proviso to Article 370, Clause 3 in two ways. First, it changes the recommending body from the Constituent Assembly to the Legislative Assembly. And second, it makes a new arrangement at variance with that specific Constituent Assembly. Both these changes are not insignificant because they modify the essential character of the proviso by substituting a particular type or kind of body with another type or kind entirely. Fourth, while the interpretation clause, namely Article 367, can be used to define or give meaning to particular terms, it cannot be deployed to amend a provision by bypassing the specific procedure laid down for its amendment. This would defeat the purpose of having a procedure for making an amendment to the Constitution of India. Fifth, the consequence of permitting amendments through the circuitous manner would be disastrous. Many provisions of the Constitution would be susceptible to amendments which evade the procedure stipulated by Article 368 or other provisions. Sixth, the previous constitutional orders which modified Article 370 through Article 367 were clarificatory and consequential. They did not have the effect of amending Article 370. We have therefore held as ultra vires the amendments which were made to Article 370, Clause 3 by taking recourse to Article 367. G, the status of the Constitution of Jammu and Kashmir. The gaps left by the non-application of some parts of the Constitution of India were filled by the Constitution of the state. After the abrogation of Article 370, as it stood before the issuance of CO 272 and CO 273, and the application of the entirety of the Constitution of India to the state, the constitution of the state does not fulfill any purpose or serve any function. Hence, the implicit but necessary consequence of the application of the Constitution of India in its entirety to the state of Jammu and Kashmir is that the constitution of the state is inoperative. On the validity of Parliament's exercise of power under the first proviso to Article 3, this is what we have said. A five-judge bench of this court in Babulal Parate held that the views expressed by the legislature of the state under the proviso to Article 3 are not binding on Parliament. If the views of the state legislature were binding on Parliament, which is not the case, there would be scope for debate on whether Parliament, in exercise of its powers under Article 356(1)(b, could have substituted its views for the views of the Legislative Assembly of the state. However, the views of the legislature of the state are not binding on Parliament in terms of the first proviso to Article 3. The views of the legislature of the state under the first proviso to Article 3 are recommendatory to begin with. Thus, Parliament's exercise of power under the first proviso to Article 3 is valid and not mala fide. The next issue is on the validity of the suspension of the second proviso to Article 3 as applicable to Jammu and Kashmir. When the reorganization bill was introduced, that is on 5 August 2019, the second proviso to Article 3 as it applied to the state of Jammu and Kashmir ceased to exist because of CO 272. Thus, the issue of whether the second proviso to Article 3 could have been suspended in exercise of the power under Article 356(1)(c) does not survive. The next issue is the validity of the Jammu and Kashmir Reorganization Act 2019. The Solicitor General, appearing for the Union of India, submitted that statehood will be restored to Jammu and Kashmir and that its status as a union territory is temporary. The Solicitor General submitted that the status of the Union Territory of Ladakh will not be affected by the restoration of statehood to Jammu and Kashmir. In view of the submission made by the Solicitor General that statehood would be restored of Jammu and Kashmir, we do not find it necessary to determine whether the reorganization of the state of Jammu and Kashmir into two union territories of Ladakh and Jammu and Kashmir is permissible under Article 3. The status of Ladakh as a union territory is upheld because Article 3A, read with explanation 1, permits forming a union territory by separation of a territory from any state. This court is alive to the security concerns in the territory. Direct elections to the legislative assemblies, which is one of the paramount features of representative democracy in India, cannot be put on hold until statehood is restored. We direct that steps shall be taken by the Election Commission of India to conduct elections to the Legislative Assembly of Jammu and Kashmir, constituted under Section 14 of the Reorganization Act by 30 September 2024. Restoration of statehood shall take place at the earliest and as soon as possible. The question of whether Parliament can extinguish the character of statehood by converting a state into one or more union territories in exercise of power under Article 3 is left open. In an appropriate case, this court must construe the scope of powers under Article 3 in light of the necessary effect of converting a state into union territories, which is that autonomy would be diminished, the historical context for the creation of federating units, and its impact on the principles of federalism and representative democracy. In view of the above discussion, the following are the conclusions. A. The state of Jammu and Kashmir does not retain any element of sovereignty after the execution of the instrument of accession and the issuance of the proclamation dated 25 November 1949, by which the Constitution of India was adopted. The state of Jammu and Kashmir does not have internal sovereignty, which is distinguishable from the powers and privileges enjoyed by other states in the country. Article 370 was a feature of asymmetric federalism and not sovereignty. B. The petitioners did not challenge the issuance of the proclamations under Section 92 of the Jammu and Kashmir Constitution and Article 356 of the Indian Constitution until the special status of Jammu and Kashmir was abrogated. The challenge to the proclamations does not merit adjudication because the principal challenge is to the actions which were taken after the proclamation was issued. C. The exercise of power by the President after the proclamation under Article 356 is issued is subject to judicial review. The exercise of power by the President must have a reasonable nexus with the object of the proclamation. The person challenging the exercise of power must prima facie establish that it is a mala fide or extraneous exercise of power. Once a prima facie case is made, the onus shifts to the union to justify the exercise of such power. D. The power of Parliament under Article 356(1)(b) to exercise the powers of the legislature of the state cannot be restricted to lawmaking power, thereby excluding non-lawmaking power of the legislature of the state. Such an interpretation would amount to reading in a limitation into the provision contrary to the text of the article. E. It can be garnered from the historical context for the inclusion of Article 370 and the placement of Article 370 in Part 21 of the Constitution that it is a temporary provision. F. The power under Article 370, Clause 3 did not cease to exist upon the dissolution of the Constituent Assembly of Jammu and Kashmir. When the Constituent Assembly was dissolved, only the transitional power recognized in the proviso to Article 370, Clause 3, which empowered the Constituent Assembly to make its recommendations, ceased to exist. It did not affect the power held by the President under Article 370, Clause 3. G. Article 370.
ஜம்மு காஷ்மீருக்கு வழங்கப்பட்டிருந்த சிறப்பு சட்டப்பிரிவு 370 ரத்து தொடர்பான வழக்கில் உச்சநீதிமன்றம் தீர்ப்பளித்திருக்கிறது. இது குறித்த விரிவான விவரங்களுக்கு செய்தியாளர் ராமகிருஷ்ணன் இணைகிறார். ராமகிருஷ்ணன், விரிவான தகவல்கள்.
ரத்து செய்தது சரிதான் என்று உச்சநீதிமன்றம் இன்றைக்கு அதிரடியான ஒரு தீர்ப்பை வழங்கியிருக்கிறது. அதே சமயத்தில் ஜம்மு காஷ்மீர் மாநிலத்திற்கு வழங்கிய அந்த சிறப்பு அந்தஸ்தை திரும்ப பெறும் சட்டத்தை வழங்கிய 370வது பிரிவை ரத்து செய்த விவகாரத்தில் விரைந்து அந்த மாநிலத்திற்கு மாநில அந்தஸ்து வழங்க வேண்டும் என்றும் உச்சநீதிமன்றம் உத்தரவு பிறப்பித்திருக்கிறது. இது மட்டுமல்லாமல் அடுத்த ஆண்டு 2024 செப்டம்பர் மாதத்திற்குள் இந்திய தலைமை தேர்தல் ஆணையம் தேர்தல் நடத்த வேண்டும் என்ற ஒரு உத்தரவையும் உச்சநீதிமன்ற நீதிபதி டி.ஒய். சந்திரசூட், கவாய் சூரியகாந்த், சஞ்சய் கிஷன் கவுல் மற்றும் சஞ்சீவ் கன்னா ஆகிய 5 நீதி கொண்ட அரசியல் சாசன அமர்வு இந்த அதிரடியான தீர்ப்பை வழங்கியிருக்கிறது. ஜம்மு காஷ்மீர் மாநிலத்திற்கு சிறப்பு அந்தஸ்தை வழங்கும் 370வது பிரிவை கடந்த 2019ஆம் ஆண்டு ஆகஸ்ட் மாதம் 5ஆம் தேதி திரும்ப பெற்றது மத்திய அரசு. அன்றைய தினம் நடைபெற்ற நாடாளுமன்றத்தினுடைய கூட்டத்தொடரில் ஒன்றிய உள்துறை அமைச்சர் அமித்ஷா தான் அந்த தீர்மானத்தை கொண்டு வந்து மசோதா நிறைவேற்றப்பட்டு குடியரசுத் தலைவர் அதற்கு ஒப்புதல் வழங்கி சட்டமாக்கப்பட்டது. அதைத் தொடர்ந்து ஜம்மு காஷ்மீர் மாநிலம் 2ஆக பிரிக்கப்பட்டது. ஜம்மு காஷ்மீர் மற்றும் லடாக் என்று 2 யூனியன் பிரதேசங்களாக மாற்றப்பட்டது. இதை எதிர்த்து பல்வேறு அரசியல் கட்சி தலைவர்கள் மட்டுமல்லாமல் மூத்த வழக்கறிஞர்களும் உச்சநீதிமன்றத்தில் வழக்குகளை தொடர்ந்திருந்தார்கள். இந்த வழக்கு என்பது உச்சநீதிமன்ற தலைமை நீதிபதி டி.ஒய். சந்திரசூட், சஞ்சய் கிஷன் கவுல், சஞ்சய் கன்னா, பி.ஆர். கவாய், சூரியகாந்த் ஆகிய 5 நீதி கொண்ட அரசியல் சாசன அமர்வில் விசாரணை நடைபெற்று வந்தது. கடந்த 2 மாதங்களுக்கு முன்பு 16 நாட்கள் தொடர்ந்து இந்த வழக்கினுடைய விசாரணை நடைபெற்று செப்டம்பர் மாதம் 5ஆம் தேதி வழக்கினுடைய விசாரணை அனைத்து முடிவடைந்து தீர்ப்பு என்பது ஒத்திவைக்கப்பட்டிருக்கின்ற இந்த சூழ்நிலை தான் இன்றைய தினம் நீதிபதிகள் இந்த தீர்ப்பை வழங்கியிருக்கிறார்கள். தீர்ப்பை பொறுத்தவரையில் ஒன்றிய அரசு ஜம்மு காஷ்மீர் மாநிலத்திற்கு வழங்கி வந்த சிறப்பு அந்தஸ்து சட்டப்பிரிவு 370 திரும்ப பெற்றது அல்லது அதை ரத்து செய்தது சரிதான் என்று நீதிபதிகள் இன்றைய தினம் தீர்ப்பை வழங்கியிருக்கிறார்கள். ஜம்மு காஷ்மீர் மாநிலத்தை பொறுத்தவரையில் இந்தியாவுடன் அது சேர்ந்த உடனேயே அதனுடைய தனித்துவமான இறையாண்மையை இழந்து விடுகிறது. ஒன்றிய அரசுடன் அந்த மாநிலம் என்பது சேர்ந்து விட்டது. அதே சமயத்தில் அங்கு குடியரசுத் தலைவருடைய ஆட்சி என்பது அமல்படுத்தப்பட்ட போது அந்த மாநிலத்தினுடைய முக்கிய முடிவுகளை மத்திய அரசு எடுக்கலாம் என்பதும் உச்சநீதிமன்ற நீதிபதியினுடைய கருத்தாக இருக்கிறது. பல்வேறு உச்சநீதிமன்றத்தினுடைய தீர்ப்புகளை அடிப்படையில் தான் இந்த தீர்ப்பு என்பது உச்சநீதிமன்றம் நீதிபதிகள் வழங்கியிருக்கிறார்கள். இந்த உச்சநீதிமன்றத்தினுடைய இந்த தீர்ப்பை வாசித்த உச்சநீதிமன்றத்தினுடைய தலைமை நீதிபதி டி.ஒய். சந்திரசூடை பொறுத்தவரையில் ஏற்கனவே மத்திய அரசை பொறுத்தவரையில் அந்த 370வது சிறப்பு அந்தஸ்து வழங்கும் அந்த சட்டப்பிரிவை ஒன்றிய அரசு திரும்ப பெற்றது அல்லது ரத்து செய்தது என்பது தற்காலிகமான ஒன்றுதான் என்றும் அந்த மாநிலத்திற்கு மாநில அந்தஸ்தை வழங்குவதற்கு மத்திய அரசு விரைவில் நடவடிக்கைகளை எடுக்கும் என்று ஏற்கனவே ஒன்றிய அரசு உறுதியளித்திருக்கிறது என்று மேற்கோள் காட்டி இந்த தீர்ப்பை வழங்கியிருக்கிறார். முக்கியமாக இந்த தீர்ப்பை பொறுத்தவரையில் மத்திய அரசு 370வது அந்த சட்டப்பிரிவை ரத்து செய்தது சரிதான் என்பது உச்சநீதிமன்ற நீதிபதிகளுடைய தீர்ப்பாக இருக்கிறது. மிக முக்கியமாக பார்க்க வேண்டும் என்றால் ஜம்மு காஷ்மீர் மாநிலம் இரண்டாக பிரிக்கப்பட்டிருப்பதை ஏற்றுக்கொண்டிருந்தாலும் அந்த யூனியன் பிரதேசங்கள் விரைவில் மாநிலங்களாக மாற்றப்பட வேண்டும் என்பது நீதிபதிகளுடைய கருத்தாக இருக்கிறது. இது மட்டுமல்லாமல் அடுத்த ஆண்டு 2024ஆம் ஆண்டு செப்டம்பர் மாதத்திற்குள் அந்த மாநிலத்தில் தேர்தல் நடத்தப்பட வேண்டும் என்று உச்சநீதிமன்ற நீதிபதிகள் இந்திய தலைமை தேர்தல் ஆணையத்திற்கு உத்தரவை பிறப்பித்திருக்கிறார்கள்.
விவரங்களுக்கு நன்றி ராமகிருஷ்ணன்.
Surprise. Pleasant surprise. Christmas, New Year, பொங்கல்னு வரிசையா festivals. Purchase எப்பவும் போல போத்தீஸ்ல தான். நீங்க வாங்குற மதிப்புக்கு ஏற்ப free discount vouchers. இத Februaryல யூஸ் பண்ணி மேலும் purchase பண்ணிக்கலாம். Pothys in festival surprise. Free discount voucher.
இந்த மாசம் அன்னிக்கிட்ட கடனை வாங்கி செலவெல்லாம் மேனேஜ் பண்ணிட்டேன். அடுத்த மாசம் யார்கிட்ட கேட்பேன்? நீங்க மட்டும் ஒரு டேர்ம் லைஃப் இன்சூரன்ஸ் எடுத்திருந்தா எவ்வளவு நல்லா இருந்திருக்கும்.
policybazaar.com இல் 1 கோடி ரூபாய்க்கான டேர்ம் லைஃப் இன்சூரன்ஸ் மாதத்திற்கு 525 ரூபாயிலிருந்து தொடங்குகிறது.
எனக்கு பாட்டிக்கு புது Dress வேணும். அம்மா தெரியுமா கொட்டிடுச்சு.
ஓகே கண்ணா, நம்ம புதுசு வாங்கிக்கலாம். இப்போல பசங்க வெரி ஸ்மார்ட். ஆனா அம்மா அளவுக்கு இல்ல. அதனால ஜென்டில் இது துணிகளை ஜென்டலா செயல்பட்டு புதுசு மாதிரி பிரகாசிக்க வைக்குது. ஜென்டில்
அத்தை அத்தை நெய்யூத்து, ஆஹா மனக்கு நெய்யூத்து, அம்மா அம்மா நெய்யூத்து.
So I begin from a different way from the history of Kashmir. Traced out the history of Kashmir relying on the contextual text of Rajtarangni and Bamzai's on culture and political history of Kashmir. Thereafter, I proceeded to analyze the circumstances in which Jammu and Kashmir Constitution Act of 1939 came into being, and then considered the submissions under different heads. Read out my conclusion. More or less, the conclusions are same, except in one of the aspects of Premnath Kaul's case, I have taken a slightly different route. That's all. So, the relationship between Union and State of Jammu and Kashmir, the concept of internal sovereignty after the IO. I am of the view that this question has been decided by the coordinate bench of this court in Premnath Kaul that the state did not lose all semblance of its internal sovereignty, which would include deciding upon the forms of government of the state upon signing of the IO. The distinguishing feature as compared to the other states was that a slightly different path was followed for the accession of state of Jammu and Kashmir by recognizing the Constituent Assembly to be formed for the state. The route of assimilation of state of Jammu and Kashmir was through Article 370. Then I've heard that I've taken note of the various factors such as Article 370's historical context in the text and subsequent practice to conclude that Article 370 was intended to be a temporary provision. As a corollary, there was a mechanism to bring the whole arrangement to an end. The effect of the power under Article 373, once exercised, would be that the article shall cease to be operative. In other words, the mechanism was meant to de-recognize the state's internal sovereignty. Thus, the exercise of power under Article 373 meant that for purposes of the Constitution of India, only the Constitution of India would apply to the Jammu and Kashmir and not any other constitution, that is the Constitution of Jammu and Kashmir. The purpose, then on Article 373, I have said, the purpose of the Constituent Assembly was to draft a constitution for the governance of the state. On the other hand, the purpose of Article 370, as noted above, was to slowly bring Jammu and Kashmir on par with the states in India. It can hardly be contended that the second and in some ways a larger purpose would be effected by the fulfillment of the first. The second purpose remained an ongoing exercise long after the State Constituent Assembly was dissolved. Thus, the conditionality in Article 373 of the requirement of a recommendation from Constituent Assembly cannot be read in the manner as to make the reference to the larger intention of the provision redundant. B. The next question is to determine what process is to be followed by the President to exercise the power under Article 373. The President can exercise this power under subclause 3 without a recommendation from the Jammu and Kashmir Constituent Assembly. When the Constituent Assembly ceased to exist, only the power of the Constituent Assembly to make the recommendation ceased to exist. That is, the proviso to Article 370 became otious. The main provision, which is the President's power to issue a declaration, continues to exist. C. Now coming to the impugned action, first the amendment of Article 373 through the route of Article 367 was invalid. When a methodology has been provided, that methodology would have to be followed, and an amendment through the back door would be impossible. D. Concurrence with the government of the state was not necessary to apply all provisions of the Constitution of India to the state. Although Article 371D requires concurrence with government of the state, in this case, the governor of the state had dissolved the Legislative Assembly of the state. There were no council of ministers, and the president had reduced to himself all functions of the government of the state under the 2018 proclamation as extended. Then on the exercise of power under Article 356 were permissible while issuing COs 272 and 273. Article 356 can be imposed once the Legislative Assembly has been dissolved, particularly since Section 92 of the Jammu and Kashmir Constitution limited the governor's role to 6 months without any scope to extend. This imposition was predicated on the failure of the constitutional machinery, which really took place prior to the government's rules. Then B, Article 356 permits the President to make irreversible changes. Both Savanji and Reddy J and S.R. Momai recognize that irreversible actions in this case, the de-operationalization of Article 370 is permitted if the proclamation had been approved by the Parliament prior to such irreversible action. C, the President reserves both legislative and non-legislative powers after the proclamation of emergency. Though Article 356 is continuance of Article 356, the former does not stipulate any bar or restriction on the Union Parliament or the President to exercise non-legislative power of the state legislature. And I've dealt with the challenge to Section 3 and 4 of the Jammu and Kashmir Reorganization Act. A, the challenge to Section 3 of the Jammu and Kashmir Reorganization Act on the touchstone of Article 3 is not required to be debated on account of the assurance on behalf of the Government of India that statehood of Jammu and Kashmir would be restored on elections being held. B, it is imperative to ascertain the views of the state legislature under the first proviso to Article 3 if the proposed bill affects the area, boundaries or name of the state. However, in the instance case, since state of Jammu and Kashmir was under President's rule and the state legislature was already dissolved, the functions of the state legislature were performed by the Union Parliament. Hence, it was not possible to ascertain the views of the state legislature. It follows that Section 3 of the Reorganization Act is valid. I have penned down an epilogue at the end of the judgment, maybe some sentiments involved. The Valley of Kashmir carries a historical burden. It has a social context. Thus, in involving constitutional status of the region, it is difficult to segregate the aforesaid. We, the people of Jammu and Kashmir, are at the heart of the debate. They have carried the burden of victims of conflict for several decades, originating from 1947 with the invasion of the Valley. Intervening political circumstances did not permit a redressal to the fullest extent of the invasion. The consequences remain in terms of parts of Kashmir being occupied by other countries. The second round of insurgency holds its origin to the latter part of 1980s. There were troubled situation at the ground level, which was apparently not redressed. It culminated in the migration of one part of the population of the state in 1989-90. It is something that our country has had to live with, and without any redressal for the people who had to leave their homes and hearth. It was not a voluntary migration. The situation became so aggravated that the very integrity and sovereignty of our country was endangered, and the army had to be called in. Armies are meant to fight battles with enemies of the state and not really to control the law and order situation within the state. But then these were peculiar times. The entry of the army created its own ground realities in their endeavor to preserve the integrity of the state and the nation against foreign incursions. The men, women, and children of the state have paid a heavy price. During my travels home over the years, I have absorbed that the social fabric waning and the consequences of intergenerational trauma on the already fractured society. I cannot help but feel anguish for what the people of the region have experienced, and I am constrained to write this epilogue. In order to move forward, the wounds need healing. What is at stake is not simply preventing the recurrence of injustice, but the burden of restoring the region's social fabric to what it historically has been based: coexistence, tolerance, and mutual respect. It is worth noting that even the partition of India in 1947 did not impair Jammu and Kashmir communal and social harmony. In this context, Mahatma Gandhi is famously quoted to have said that Kashmir was a ray of hope for humanity. The first step towards this is to achieve a collective understanding of the human rights violations perpetuated both by state and non-state actors against the people of this region. There have been numerous reports documenting these incidents over the years. Yet, what is lacking is a commonly accepted narrative of what has happened, or in other words, a collective telling of the truth. Internationally, the right of victims of human rights violation and the truth is an end itself. It encompasses a structural investigation of the events and social political structures that led to the atrocity, the particular circumstances of individual suffering, and an authoritative reporting of the results of the investigation. Additionally, truth-telling provides an opportunity for victims to narrate their stories, which facilitates an acknowledgement from those responsible for perpetuating the wrongs and from the society as a whole. This paves the way for reconciliation. While there are different ways of achieving these objectives, Truth and Reconciliation Commissions have been particularly effective globally. South Africa Truth and Reconciliation Commission was set up to investigate human rights violations perpetuated during the period of apartheid regime. It served as a means of reckoning or a catharsis for victims and fostered peace building. Reflecting on its success, Albie Sachs J. noticed, as a result of the TRC, the private sorrow and grief of tens of thousands was publicly acknowledged to an embracing and personalized way. Another form of acknowledgement emerged from perpetrators themselves. They had to come forward openly in front of the television cameras, owning up their crimes. Finally, there was acknowledgement by the whole country that these things have happened and can happen again, that we needed to fit all these facts together in some kind of significant pattern, which would enable us to understand their genesis and do what we could do to minimize any possibility of their reoccurrence. In the past, calls for setting up of Truth and Reconciliation Commissions have also been echoed by different sections of the Valley. In view of the inroads made globally and indigenous requests for truth and reconciliation, I recommend the setting up of an impartial Truth and Reconciliation Commission. The Commission will investigate and report on the violation of human rights both by the state and non-state actors perpetrated in the Jammu and Kashmir at least since 1980s and recommend measures for reconciliation. The Commission should be set up expeditiously before memory escapes. The exercise should be time-bound. There is already an entire generation of youth that has grown up with a feeling of distrust, and it is to them that we owe the greatest day of reparation. At the same time, considering the significance of the matter and under sensitivities involved, it is my view that it is for the government to devise the manner in which it should be set up and to determine the best way forward for the Commission. I am alive to the challenges of recommending of the setting up of the Truth and Reconciliation is beyond the realm of the court. However, I am of the view that transitional justice and its constituents are facets of transformative constitutionalism. Globally, constitutionalism has evolved to encompass responsibility of both state and non-state actors with respect to human rights violations. This includes the duty to take reasonable steps to carry out investigation of violations. It is this context that the proposed Truth and Reconciliation Commission accords with constitutionalism. Our Constitution is no different and is designed to ensure that courts offer justice in situations where fundamental rights have been violated. In doing justice historically, our courts have been sensitive to the social demands of our polity and have offered flexible remedies. In Vishaka and others was the state of Rajasthan, this court issued guidelines to address the workplace sexual harassment in the absence of an enacted law, which operated until the Parliament enacted the Sexual Harassment of Women Act. As a word of caution, the Commission, once constituted, should not turn into a criminal court and must instead follow a humanized and a personalized process, enabling people to share what they have been through uninhibitedly. It should be based on a dialogue, allowing for different viewpoints and inputs from all sides. In this context of South Africa's Truth and Reconciliation Commissions, Albie Sachs observed, "Judges do not cry. Archbishop Tutu cried. It was not a court of law in the sense of an austere institution making a highly formalized finding. It was an intensely human and personalized body there to hear in an appropriately dignified setting up what people had been through. There were comforters sitting next to the witnesses. In a court of law, no one is there to help the witness, to pat the shoulder or provide water or tissues when the person weeps. Frequently, the sessions would start with a song in a beautiful African harmony, intended to give a sense of encouragement and support to everybody present. Or it could begin with prayers, and therefore people spoke and spoke in all regions and in all languages of the country. The testimony was televised, and thus the nation became witness to what has happened and heard the stories directly from the mouths of persons concerned. Those who spoke were not complainants in court denouncing accused persons in the dock, nor were they litigants demanding damages for themselves, so that the greater the loss, the greater the sum would be received. Taking a leaf out of the South African book, The Principle of Ubuntu, or The Art of Humanity and Inclusiveness should be central to the process. This will facilitate a reparative approach that enables forgiveness for the wounds of the past and forms the basis of achieving a shared national identity. Needless to say, the Commission is only one of the many avenues towards the goal of systematic reforms. It is my sincere hope that much will be achieved when Kashmir opens their hearts to embracing the past and facilitating the people who were compelled to migrate to come back with dignity. Whatever has been, but the future is ours to see.
A judgment is a decision which gives reasons to arrive at and reach a conclusion. By that stretch, my order is not a judgment. We have only two judgments. Both judgments are in seritum and uniformly agree that Article 370 of the Constitution of India was a feature of asymmetric federalism and not sovereignty. Article 370 was enacted as a temporary provision and did not have a permanent character. The abrogation of Article 370 does not negate the federal structure, as citizens living in Jammu and Kashmir do and will enjoy the same status and rights as given to citizens residing in other parts of the country. Paragraph 2 of CO 272, by which Article 370 was amended by taking recourse to Article 367, is ultra-virus and bad in law, albeit it can be sustained in view of corresponding power under Article 371D. More importantly, Article 370 has been made inoperative in terms of Clause 3 to Article 370. Lastly, CO 373 is valid. I have agreed with what Justice Chandrachud has said, Chief Justice has said with regard to Article 356 of the Constitution of India. I have also made reference to Rameshwar Prasad and others versus Union of India and others, with which I respectfully agree. I also agree with the conclusions recorded by Dr. G.Y. Chandrachud, taking record of the statement made on behalf of the Union of India for restoration of the statehood of Union Territory of Jammu and Kashmir while upholding creation of Union Territory of Ladakh. Then I have agreed with Justice Kaul with regard to interpretation on Article 370, Clause 3.